We'll go now to section 14. Take note that under section 14, it talks about two animals. The first is your amendment and the second one is your substitution. Ang palaging tinatanong ng mga professors ninyo at sa bar exams is about the amendment. So, as early as now, I want you to realize that there are two kinds of amendments. First is your formal amendment, and the second one is the substantial amendment. You have to know this one para mas madali ninyong i-distinguish. Also, take note that you can amend your information. Take note ha, you are amending your information. You can do that before plea or before arraignment. And the next one is after plea or after arraignment. So here is a quick look of the rule on amendment. We said that amendment of your information can be made before plea. But what is the rule if you are going to amend your information before plea? Take note that there is a general rule, and that general rule is you can amend without leave of court. You can amend your information without leave of court before plea. As to formal amendments and as to substantial amendments. But since we are talking about the general rule, of course, palaging may exception. And what is that exception? You need leave of court for two matters. We will discuss that later. Next, after plea. After plea, iisa lang ang rule. And what is that rule? You need leave of court. You need leave of court if you are going to amend your information after plea, and take note that it covers only formal amendments. It covers only formal amendments, but wag kayong mag-stop dyan because even if it covers only formal amendments, you have to make sure that it will not prejudice the rights of the accused. As to substantial amendments, you cannot amend your information even if it is made with leave of court and after plea. Take note of that. Again, before plea, the general rule is that you do not need leave of court. You can amend without leave of court. A complaint or information may be amended either in form or in substance without leave of court at any time before the accused enters his plea or before arraignment. And we are talking only about the general rule. There is an exception, and the exception is you need leave of court. But when do you need leave of court? Meron lamang dalawang scenario. So, before plea, you have to file leave of court if you are going to, number one, downgrade the nature of the offense charge. Just like for example, if it is from murder, you will downgrade it to homicide. Then in that case, you need leave of court. Number two is if you are going to exclude any accused from the complaint or information, then again, you need leave of court. So kung 5 yang akusado, then you are going to take away accused number 1, or you are going to exclude accused number 1, then you need leave of court. The requirement of the rules is there must be a motion filed by the prosecutor, then you have to notify the offended party, and then you have to file leave of court. The court shall state its reasons in resolving the motion, and copies of its order shall be furnished all parties, especially the offended party. Take note of this ha, very important. This is a bar topic. After plea, take note that wala nang general rule, wala nang exception. There is only one rule. One rule when it comes to amendment of your information after plea. And that rule is you need leave of court. So what is covered in your amendment? Only formal amendments may be made. Ano ba itong formal? That is your clerical error. That is your typographical error. But take note ha, that even if it is only a typo error or clerical error, you have to make sure that it will not cause prejudice to the rights of the accused. Again, you have to make sure that these formal amendments will not cause prejudice to the rights of the accused. Ang common example na binibigay dito ng mga reviewers is, if there is a person who is accused of rape, and in the information, it was indicated that the victim or the offended party is 18 years old. But it turned out na nagkaroon ng typo error. The offended party is actually 8 years old. So, that is statutory rape. So, even if it is only a typo error, definitely it will cause prejudice to the rights of the accused. Kaya, make sure how when you write in your bar exams or even in your exams, you make sure to put that formal amendments that will not cause prejudice to the rights of the accused. Formal amendments that will not cause prejudice to the rights of the accused. So when can you say that an amendment is formal? According to the Supreme Court, dalawa ang test. First is, you have to make sure that the defense is still available, and you have to make sure that the evidence that you have already gathered or you have already prepared can still be applied even if the information is already amended. Because if you cannot use your defense or if you cannot use the evidence that you have gathered, then that is no longer a formal amendment but rather a substantial amendment. So again, dalawa, defense and evidence. So, going back to our example, kung binago yung age ng offended party or ng victim from 18 years old to 8 years old, definitely, yung defense na prepare ni accused as well as the evidence gathered by the accused can no longer be used because that is a statutory rape. This is the reason why I am emphasizing to you this phrase, it will not cause prejudice to the rights of the accused. So again, the rule of amendments in criminal procedure is you can do it before plea and after plea. And if you are going to do it before plea, then you do not need leave of court, both as to formal amendments and as to substantial amendments. But take note that we are talking only about the general rule. There is an exception. If what you are going to amend before plea is you are going to downgrade the nature of the offense, or if you are going to exclude any accused, then in that case, even if the amendment is made before plea, you need leave of court. So this is the exception. How about after arraignment or after plea? What is the rule? There is only one rule. You need leave of court. You need leave of court, and take note that it only covers formal amendments, and these formal amendments should not cause prejudice to the rights of the accused. Take note of that, formal amendments only, and it will not cause prejudice to the rights of the accused. Substantial amendment not allowed after plea because that will violate the constitutional rights of the accused. Let's compare it to civil procedure so that you will appreciate in civil procedure, amendment is also available, and amendment can be done before the service of a responsive pleading and after the service of a responsive pleading. So kung sa criminal procedure, the point of reference is before plea or before arraignment, and after plea or after arraignment, then in civil procedure, the point of reference is before the filing of an answer. General before the filing of an answer or a responsive pleading, and after the filing of an answer. So, marami kang pwedeng gawin dyan. Before the filing of an answer, you can file a motion to dismiss, you can file a motion for bill of particulars, and you can amend any pleading as a matter of right. In criminal procedure, before arraignment, you can file a motion to quash. You can file also a motion for bill of particulars, and then you can also amend the information provided that you comply with these rules. So in civil procedure, if you are going to amend before the service of a responsive pleading, then you can amend without leave of court. Without leave of court. But ito ha, tatandaan nyo that you can do it only once. You can do this only once. And what is the coverage? It covers substantial amendment. Basis, Section 2 of your Rule 10, ang tawag nga natin dito is amendment as a matter of right. Amendment as a matter of right, a party may amend his pleadings once as a matter of right at any time before a responsive pleading is served, or in the case of a reply at any time within 10 calendar days after it is served. After the service of a responsive pleading, can you still amend? Answer is yes, but you need leave of court. You need leave of court, and what is the coverage? It covers substantial amendment. So unlike in criminal procedure na after plea, you can amend but with leave of court, but it only covers formal amendments, and you have to make sure that it will not cause prejudice to the rights of the accused. In civil procedure, you can amend substantial matters and you need leave of court. Basis, this is your Section 3 of your Rule 10. Substantial amendments may be made only upon leave of court, but you have to make sure that that leave or that motion was not intended to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning which could be amended. And what is required? There must be a motion filed in court, notice to the adverse party, and an opportunity to be heard. So, ang pinag-uusapan natin sa civil procedure is substantial amendment. How about formal amendments? Ano ang sinasabi ng Section 4, Rule 10? As far as formal amendments is concerned, then it can even be summarily corrected by the court at any stage of the action. It can be summarily corrected by the court at any stage of the action, and formal amendments can be made by the court at its initiative or on the initiative of the parties by filing a motion, provided that no prejudice is thereby caused to the adverse party. So this is the summary of the rules on amendment. So last topic is about substitution. Take note that we are talking about substitution of an information and not about substitution of an accused. Take note ha, substitution of an information. And if you are going to be asked about substitution of an information, the answer can be found in the last paragraph or the third paragraph of Section 14 and correlate it immediately to Section 19 of your Rule 119. So when it becomes manifest at any time before judgment that there was a mistake in charging the proper offense, and the accused cannot be convicted of the offense charge or any other offense necessarily included therein, then what is the duty of the court? The court shall not discharge the accused. The accused shall not be discharged if there appears good cause to detain him. In such case, the court will commit the accused to answer for the proper offense and dismiss the original case upon the filing of the proper information. So this is the substitution. So again, for substitution, what is the requirement of the law? You have to do it before judgment, and the reason why there is a substitution is because the accused cannot be convicted of the offense charge, or the accused cannot be convicted of any other offense that is necessarily included in the offense charge. And you have to make sure ha, ito ang number 3, pinaka-importante, that the accused will not be placed in double jeopardy. The accused would not be placed in double jeopardy, therefore, substitution now is allowed. Last sentence of your section 14, I have to emphasize this kasi for sure, kung kayo ay tatanungin ng mga professors nyo or even sa bar exams that can the court require a witness to post a bail, pag hindi nyo nabasa kung anong argumento ang gagamitin nyo dyan. But the rules is very clear that the court may require the witnesses to give bail for their appearance at the trial. So bail is available, not only to the accused, but bail is also applicable to witnesses. The court may require the witnesses to give bail for their appearance at the trial.